Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today because you have a case in County Court at Law Number 2. The case that you have in County Court at Law Number 2 is a criminal case. You have either civil cases or criminal cases. The case that you have in this court is a criminal case. Now, criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your most serious type of criminal offenses. Your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that they are not as serious as a felony offense. And when I use the term serious, what I'm talking about is I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. For example, felony cases are divided into 5 categories. And we'll start at the top and work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If a person is convicted of a third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life and a fine that does not exceed $10,000. Now, if a person is convicted of a capital murder, which is the highest felony, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned earlier, you don't have to worry about that because the case that you have in this court is a misdemeanor case. Misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only, a fine that does not exceed $500. Now, your Class C misdemeanors are offenses that occur, and they are normally handled in the city court, which is the municipal court, or the JP court, which is the justice court. For example, not wearing your seatbelt is a Class C. Having an expired sticker is a Class C. Speeding is a Class C. Those cases, they are normally handled in the JP court or the city court, and they come to this court when a person is convicted in one of those courts, and then they appeal that case, and then the case gets appealed and it comes to this court. And the punishment range does not change when it comes to this court. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days, which is 6 months in the county jail, a fine from $0 to $2,000. If a person is convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, which is a year, or a fine from $0 to $4,000, or you could be given both such fine and confinement. You could be given both such fine and confinement in a Class A or and a Class B. Now, as a defendant in a criminal case, you have rights. One of the rights, or at least the first right that we're going to talk about, is your right to have an attorney. The documents that is on the clipboard, the first document that is titled Judge's Explanation of Rights to Defendant Without an Attorney, it talks about your right to have an attorney. I'm going to go over that document with you. As a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. And number three, you may represent yourself. Now, you can represent yourself if you waive, which means to give up your right to have an attorney. If you want an attorney and you have enough money to hire an attorney, your case will be reset. Reset means that you'll be given another court date to give you time to hire an attorney. If you want an attorney, but you do not have enough money to hire an attorney, you would need to fill out a financial questionnaire. Now, the financial questionnaire should be the third document on the clipboard that is titled Jefferson County Affidavit of Indigence. You'd have to fill out that financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver. The waiver is you saying that you understand that you have a right to have an attorney. However, you'll be waiving your right to have an attorney. You have to sign a written waiver of your right to be represented by an attorney. Now the written waiver should be the second document on that clipboard that's titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. I'm going to go over that document with you in about 2 minutes. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. Now, those of you who will be waiving your right to an attorney, you'll be representing yourself, you'll have an opportunity to speak to the prosecutor. But as I mentioned earlier, you cannot speak to the prosecutor unless you first sign the written waiver of your right to be represented by an attorney. At the bottom of this document, the first document, Judge's Explanation of Rights of Defendants Without Attorney, in bold letters it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. Now, if you have already been appointed a court-appointed attorney in your case, you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is to waive your right to have an attorney, or to give up your right to have an attorney, and you would like to represent yourself, then you will place your initials on the on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled Defendant and you would date it today's date, April 23rd of 2024. Now, the second document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial, that's for individuals who will be waiving their right to have an attorney and they'll be representing themselves. The document states as follows: I have been advised of the nature of charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 23rd day of April of 2024 by the County Court of Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed free of charge, if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. And if that's your choice, you say, I hereby waive my right to counsel. Once you read that, then you'll sign your name on the line that is titled defendant, and you will date it today's date, April 23rd of 2024. As a defendant in a criminal case, you also have other rights. One other right that you have is a right to have a trial by jury. For those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to serve as jurors in your case. They will listen to all the evidence. They will listen to the arguments. They will deliberate, and then they will decide to find you either not guilty or guilty of your charge. You also have a right to waive your right to have a trial by jury, which means you have a right to give up your right to have a trial by jury. And by doing so, your case will come before the court or before the judge in one of 3 ways. One way it can come before the judge is by way of a trial without a jury. We call that a bench trial. It's a trial by judge only. The judge will listen to the evidence, listen to all of the arguments, and then the judge will decide after applying the facts to the law, the judge will decide whether or not to find you not guilty or guilty. Now, you also have a right to waive your right to have a trial by judge. And if you do so, the second way that your case can come before the court is by way of a plea bargain. It can come by way of what we call, let me explain to you what a plea bargain is. A plea bargain is, it's an agreement that you or you and your attorney have reached with the state, the prosecutors, who works for the district attorney's office. They've reached an agreement to settle your case. If you have reached an agreement to settle your case, we call that an agreed plea bargain agreement. If you have not reached one, it's an unagreed plea bargain agreement. Now, so the second way your case will come before the judge, if you have waived your right to have a trial by jury, is by way of an agreed plea bargain agreement. Now, as I mentioned earlier, it's an agreement that you have worked out with the state. And if you have reached a plea bargain agreement with the state, then it will come before the judge. The judge could do one of 2 things. The judge could either accept or reject the plea bargain agreement. If the judge rejects your plea bargain agreement that you have made with the state, then you have a right to withdraw or take back your plea. So for example, let's say you and the state have reached a plea bargain agreement for you to be on probation. Okay. And it comes before the court and the judge says, well, I'm not going to follow that agreement. And then you say, well, judge, since you're not following the agreement that I made with the state, I withdraw my plea. I take it back. Now, I've used the word plea, and let me explain to you what that is. A person going to enter one of three pleas. They could enter a plea of not guilty, they could enter a plea of guilty, or they can enter a plea of no contest. If a person enters a plea of guilty, he's telling the court that he committed the offense that he has been charged with. If he's entered a plea of not guilty, they're saying that they did not commit the offense that they have been charged with. Or if they enter a plea of no contest, they're telling the court that they will not be fighting or contesting the charges. Okay? So when a person enters a plea, they're either entering a plea, and with a plea bargain agreement, they either enter a plea of guilty or no contest. Okay? And so in the example that I gave, if the judge does not follow the plea bargain agreement, if you enter a plea of guilty or no contest, then you can tell the judge, well, I withdraw or I take back my plea of guilty, no contest, since you are not following the plea bargain agreement. You have a right to do that. All right. Now, the other way your case will come before the judge is by way of an unagreed plea bargain agreement. Well, before I go to the unagreed plea bargain agreement, let me go back to the agreed plea bargain agreement. Let's say that I mentioned that if the judge rejects the plea bargain agreement, you can withdraw and take back your plea. Now, if the judge accepts the plea bargain agreement, and within 30 days after pleading guilty and no contest, you decide that you would like to appeal your case. Appeal is mean that you would like a higher court than this court to look at the case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. We call that an appeal. If you want to appeal your case after the judge accepted the plea bargain agreement, you have to get permission from the judge to appeal your case. If the judge gives you permission to appeal your case, then your case will leave this court and go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. They will review your case. They will review your case to see whether or not you've been wrongfully convicted or whether or not this court committed an error by convicting you. They can do one of two things. They could either grant or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal it to a higher court than the Ninth Court of Appeals. You could appeal it to the Texas Court of Criminal Appeals, which is located in Austin, Texas. It is the highest criminal court in the state of Texas. You will have to file what is called a pro se petition for discretionary review. What that means is this. Pro se means you are representing yourself. You don't have a lawyer representing you. Petition, you're asking them to review, you're petitioning the Texas Court of Criminal Appeals to review your case, to see whether or not your appeal should have been granted, or whether or not this court committed an error by convicting you, or whether or not you were wrongfully convicted. They can do one or two things. They can grant your pro se petition or they can deny it. If they grant your pro se petition, they can just simply find you not guilty. Or they could send the case back up to the Ninth Court of Appeals with orders, or they could send it back down to this court and order this court to give you a whole new trial. Okay? Now, if they deny your pro se petition, at that point, your conviction will stand. All right. Now, I mentioned that if you waive your right to a jury, your case will come before this court in one of three ways. One way I mentioned was the bench trial. The second way I mentioned was an agreed plea bargain agreement. Now, the third way that it will come before the court is by way of an unagreed plea bargain agreement. That means you and the state have not been able to reach a plea bargain agreement. And so since you and the state have not been able to reach a plea bargain agreement and you still would like to enter a plea of guilty or no contest, then your case will come before the court by way of an unagreed plea bargain agreement. It comes before the judge. And the judge will decide what your punishment will be in your case within the punishment range that the court has. Okay. Now, I mentioned that you had a right to have a trial by jury. Well, I mentioned that you had a right to have an attorney. I mentioned that you have a right to have a trial by jury. I mentioned that you had a right to have a bench trial. You have a right to have an agreed plea bargain agreement. And you have a right to have an unagreed plea bargain agreement. The other right that you have is you have a right to have witnesses to come to court to testify. Witnesses, they sit in this chair with a microphone. It's in front of the chair. And what witnesses do, they can testify either for you or against you. If you're representing yourself, or if you have a lawyer representing you, you can ask some questions. We call that either direct examination or cross-examination. Now, you also have a right to waive your right to have witnesses to come to court. Waiving your right means that you're giving up your right to have witnesses, and by doing so, you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. You also have a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case. Now, the state of Texas, the government, the DA's office cannot force you to testify against yourself in your case because you have a Fifth Amendment right against self-incrimination. Now, you can waive your Fifth Amendment right against self-incrimination, and that means you can give up your Fifth Amendment right against self-incrimination and decide to take the stand and testify. That's your right. But if you don't waive it, the state cannot force you to take the witness stand and testify. Okay. The other right that you have is a right to have discovery. Discovery means you have a right to see or discover the evidence that the state has against you. Okay. We call it discovery. You have a right to have access to your statement, witness statements, police reports, lab reports, audio recordings, video recordings, any type of documents or instruments that the state has as evidence in the case that they will be using against you. You also have a right to waive or give up that right, which means you have a right to say, well, I want to have access to it. Okay? That's a right that you have. Now, everyone that's here, you were arrested. Hold on a minute. Turn the camera around. Everyone that's here, you have been, arrested, and you're out of jail on bond, and you're out of jail either on a cash bond, which means you paid the full amount of the bond to get out of jail, or you're out of jail on a surety bond, which means that you paid a bondsman a percentage of the bond to get out of jail, or some of you may be out of jail on a PR bond or a personal recognizance bond, which means that you didn't have to pay anything to get out of jail. You were released under your own personal recognizance with a promise to appear in court. I've said that to say this. Every day that you have spent in jail, it can be used as credit towards your punishment. So, for example, if let's say you spent 5 days in jail and you and the state have reached an agreement a plea bargain agreement for you to serve 5 days in jail. That means you won't have to serve any more time in jail. Why? Because you've already served 5 days in jail. Therefore, you'll be given credit for the time that you have already served, which is 5 days. Now, if the state is offering in the plea bargain agreement for you to serve 7 days in jail and you've served 5 days in jail, that means you only have to serve 2 days in jail. Why? Because we're going to subtract the 5 from the 7, and that leaves 2. Every day that you spent in jail also can be used as credit toward your fine and court costs. Every day that you spent in jail, you are credited at $100 per day that will go toward your fine and court costs. So let's say, for example, you spent 5 days in jail. That's $500 credit that can go toward your fine and court costs. Now, if the state is offering fine and court, through a plea bargain agreement, fine and court costs of $500, that simply means you won't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired, which means you won't have to pay it. Now, if the state is offering fine and court costs of $700, you spent 5 days in jail, which is $500. That means you only have to pay $200 because we're going to take $500 from the $700. That leaves $200. Now, and you'll be required to pay the fine on the day that the case is disposed of. Now, if you are unable to pay the fine on the day that the case is disposed of, then we can put you on what is called a payment plan, which means you could pay off so much a month until the balance of the fine and court cost is paid off. If you cannot pay off, cannot pay the balance because you do not have the income, no problem. Because we can convert your fine and court costs to community service. Every 1 hour community service that you perform at a nonprofit organization in this area, $12.50 will go towards your fine and court costs. So, for example, if you work 8 hours, that's $100 that will go toward your fine and court costs. So, in the scenario that I mentioned earlier, if a person owes $200, they don't have to work 16 hours, like 2 8-hour days, and that will be equivalent to that will be $200 that will go toward their fine and court costs. Okay, now, Jefferson County District Attorney's Office has a program that is called pretrial diversion. It is a program where they will dismiss the case and you could get it removed from your record. In order to qualify for the program, it has to be your first time getting in trouble. It cannot be an offense for evading arrest or unlawfully carrying a weapon. And you have to have an attorney to assist you at making the application to the district attorney's office. Now, if you qualify and you are admitted into the program, as I mentioned earlier, the case will be dismissed. And if you successfully complete the program, you can get it expunged, or which means erased, deleted, or wiped off of your criminal record. Okay? And again, this is for individuals who is first time getting into trouble. Now, if you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office also has another program, which is part of the pretrial diversion program, that is called Veterans Court. It is a program for veterans only. With that program, once you get into the program and complete the program, they will dismiss the case. And you can get what is called a non-disclosure. A non-disclosure basically is your record is sealed to the general public. Okay? And so now I use the term general public. Now the government can have access, But the general public, which is most of the public, cannot have access because it'll be sealed. Okay. Now, if you're interested in any one of those programs, just let us know, and we will be able to direct you to the people that you need to talk to get into the program, or we can give you the brochures and applications that you need to apply. Okay. Now, this court, County Court at Law number 2, Jefferson County, Texas, has a program that is called the CSI program. CSI stands for Community Safety Initiative. That is a program that I started within the first 100 days of taking office in March of 2017. And the program is designed to address the issue of what we call recidivism. Recidivism is where people commit crimes over and over. And so we address that through our Community Safety Initiative. With the Community Safety Initiative, we have partnerships with agencies in the Southeast Texas region. One of the partnerships that we have is with Spindletop Center. Spindletop is our local mental health center in the Southeast Texas area. Now, with Spindletop, we have some folks from Spindletop who's going to come here, who's going to talk to you in a few minutes. They're going to let you know a little bit more about the program and programs that Spindletop has to offer. But generally, with the Spindletop program, they have the ability to do a private interview. It could either be here in the jury room, or they can do it at their facility, or they could do it over the phone, whatever is convenient. They have the ability to do an assessment, develop a treatment plan for either outpatient or inpatient treatment. Now, in order to qualify for the program, you do not have to be incompetent or insane. You could merely suffer from anxiety, depression, or any other host of mental illnesses. Spindletop has the expertise to address whatever mental health issue that you have. Now, if you have issues with drugs or alcohol, Spindletop has a program that is called ATAR. ATAR stands for Addiction Treatment and Recovery. And our local mental health council have a program that is called OZAR. OZAR stands for Outreach Screening and Assessment and Referral. Both of those programs are drug and alcohol recovery programs. With those programs, individuals are screened, given an assessment, and then treatment plans are developed, and they're referred to facilities to address either outpatient or inpatient treatment. If you are unemployed or you're looking for a better job, we have a partnership with our Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program in the hotel industry, the shipping industry, and the chemical industry. Once individuals are trained in one of the areas that they select, then CICE will assist them at getting a job in the area that they're trained in. If you have not graduated from high school and you would like to get your graduate, or you would like to get your GED, which is a graduate equivalency diploma, well, you can get that through CICE. Now, all these programs that I just mentioned are free. They do not cost you anything but time. And I like to say in this court, we do not just give time, we take our time. And that's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we believe that if we, make a difference in their lives, we'll make a difference in their home, we'll make a difference in their home, then we'll make a difference in the community, because what comes out of the home goes into the community. And with these programs, we like to say we are able to produce productive people And if we produce productive people will not commit crimes because they have too much to lose. And so I always say that when you come to county court at law number 2, we do not have court as usual, we have unusual court. Now, if you're interested in any one of these programs, just let us know. And we have brochures that we can hand out to you with phone numbers where you can make contact with individuals to get into these programs. The other beauty thing, the other thing about this program that's very interesting is that all of these programs that I just mentioned can be used as community service. So for example, let's say you were ordered to pay a fine, but you can't pay the fine. So we converted it community service. And let's say you might have some mental issues that you're dealing with. Every 1 hour that you're in counseling, $12.50 is going toward the fine and court costs, and 1 hour is going toward being in the community service. And then the other thing is you're in the program. So if you're working on your GED, the same thing happens. Or if you in job training, or in 1 hour in a GED class or in job training, $12.50 is going toward your fine and court costs. 1 hour is going towards community service. And so I always tell people this: you're not killing 2 birds with 1 stone, you're killing 3 birds with 1 stone. Because you're in the program, you're getting 1 hour toward your community service, and then $12.50 is going toward your community service. Okay, so you're doing 1 thing, but you're getting credit for 3. Okay, so if you're interested in this program, just let us know, and we'll be happy to get you started in participating in these programs. Now, as I mentioned earlier, we have some folks from Spindletop. We have Deputy Hinton and Chris. They're going to come to you now and tell you something, tell you more about the program and programs that Spindletop has to offer. Deputy Hinton and Chris.
You're welcome. Morning. Morning. My name is Steve Hinton. I'm a mental health deputy licensed by the State Commission here with the Sheriff's Office, and my coworker, Chris. Now, this is a qualified mental health professional. The reason we are both here this morning in this courtroom is the judge cares about every single person who comes to the bench. Judge has found, and statistics prove, that those who have legal issues commonly have mental health needs, substance use disorders, or sometimes it's a lack of community resources to help you improve particular situation.
I know the judge did mention anxiety and depression, typically that's what we see. Almost every single person, and nobody's gonna deal with that at some point in their life. And a lot of times, the process doesn't. And I'm just like, inpatient, outpatient, you can provide information on resources, we can't send anybody anywhere, so please don't worry about that. If you have information you need for yourself or someone you care about, it doesn't matter if you're a defendant or if you're here to support. Every single person should have this on their clipboard, so that if anyone else needs anything, please let me know. There's a lot of really great community resources out there, not just here, just in Kansas and generally, but they're not what advertised because they are well funded, and sometimes even just finding the names belong to you and individuals.
Maybe this is your first time to be here, maybe it's your 10th time to be here in court. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. We need you to share that need with us so we can see best how to advocate and help you. And Chris will show you exactly how to do that very privately.
So again, as I said, everybody can only one equivalent, right? We do also offer this to the support that comes in here, because it doesn't matter if you're here for yourself or someone else, doesn't matter if we need the information for you or someone you care about. We function as a giant loophole. We understand that a lot of, like I said, a lot of community resources, but very little access, and sometimes support is the biggest resource we need. It's really hard to find these things or just find someone to talk to about it. We understand also that, it's financial as well. Maybe you find a resource, but maybe you don't know how to get on the sliding fee scale, or maybe you don't know how to get it set up to where it's not going to cost you. We're here to help. That's really the only thing we're here to do. We're here to talk to you. We're here to set up whatever you need to set up, or just be with you throughout the process. If you have something you need, we're here to find it. This is built like a baseline of a consent form. The reason it's built this way is that you know that the information you put around is protected under state law, the same way your medical information would be. On here, there are several different options. If the only thing you can send to you on this, you may contact me once in a manner you choose. On here, there's several different options for call, text, email, or you can speak with me a day if you want to. If you do choose to speak with me today and the court finishes up, if you finish up the court and you don't want to wait, that's okay. We'll set up a time. If you put down you want to call or text and you don't reply back, that's okay. It's not gonna be a robocall situation where I blow up your phones, I promise. I mean, neither of us have time for that. What's important is that you have the contact information so that you can get a hold of me if you need me. If you do reply back, if you do keep calling back, the big thing is that we know you all showed up today. I'm sure there were plenty of people outside whose names are called, but they did not come in here. We know you all make the effort to be here. And we want to match that, so we'll work as hard for you as you do for yourself. I know that sounds cliche, but again, we want to match that. So if you keep applying back, if you keep telling us what you need, we will do our best to help.
I also have a flyer here that I want to get in everyone's hands before you do. And on the back, it tells you some of the advantages of actually participating, but on the front, it has a 1-800 number. If you ever find yourself in that same place, you can call that number and get help immediately.
So the big thing about that is, remember I said, like, there's a lot of really great resources in Texas. We understand a lot of people feel it's important to you guys from nowhere close to here or not even from the state. And it's not really our ability to work with you or help you find something. All you need to do again is just reach back out to me and reach out to me. That is the very first resource we can give you. That number is active almost worldwide. I say almost because we know in Texas it's way too many dead zones. We're in open numbers. But it is a crisis hotline. If you find yourself needing to talk to somebody, meaning how you or someone you care about is in a moment that you need to help them with, if you call at 6 a.m. on Tuesday and they will pick up. There's also another hotline number on there too, that's also 24/7. If there's something outside of a crisis that you need to, that's why it's important to make sure you get my phone number so that you can contact me at my work number and you can set up work if you need to. Because we want to be there for you. We know that you guys are, this should not be the first place that we hear about this kind of stuff, right? I'm sorry, this is the place I'm talking to you. I know it's not home anybody wants to be. Voters want to be here for you.
Just shortly, the court is going to go into recess. When it does, we'll come out there, there's a document from you, and I'll also be handing this out at that time. And we'll answer any questions you have as well in this review.
Also, if anybody doesn't have one of these appointments and wants one, I'll bring them up and walk in there. We have friends who have access to it. Just let us know. Again, we're here to help.
Thank you for listening. You're very kind. Thank you, Your Honor.
Okay, thank you, Deputy Henry Griffin. Okay, ladies and gentlemen, before we go into recess, I need to tell you some things. First thing is make sure that you fill out the paperwork on the judge's explanation. You need to fill that out and sign it. For those of you who will be applying for a court-appointed attorney, you're going to fill out the front page, the first page, and half of the second page. The bottom part of the second page is for the court, and the third page is also for the court. And those of you who will be waiving your right to an attorney, you'll be signing a written waiver of your right to an attorney. And you're going to read that and then sign where it says defendant and the day's date. Now, that paperwork is going to be picked up. Now, if you need assistance at filling the paperwork out, we have our court personnel who's here who will be able to assist you at filling the paperwork out. So if you have some issues or some problems, don't worry. We have someone who can help you to fill the paperwork out. The other thing is, we're going to pick that paperwork up, and it's going to take us some time to pick the paperwork up, evaluate it, and then once we finish picking up the paperwork and then evaluating all of the paperwork, we're going to call you up to the bench one at a time, okay? And you'll stand before the bench, and then we'll go through that paperwork. Now, For those of you who need to use the restroom, there are two restrooms right outside in the hall. The men's restroom is in front of County Court at Law number 2. And the female restroom is on the opposite side of the hall in front of the 172nd District Court. Okay, now, once you leave the restroom, you can come back in the court. Now, do not leave the courthouse, because if you leave the courthouse and we call your name, you're not here, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Okay, so at this time, the court will be in recess. As I mentioned earlier, if you need any assistance with filling the paperwork out, just raise your hand and we'll have someone from our court personnel who will come by to assist you. At this time, the court will be in recess. bench. First case is cause number 24CCCR 0210. Case is style of state of Texas versus Donovan Covell Jasper. Mr. Jasper, your full name is Donovan Covell Jasper. Mr. Jasper, would you please raise your right hand? Mr. Jasper, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Jasper, you may put your hand down. How are you doing, Mr. Jasper? I'm doing fine. Thanks for asking, Mr. Jasper. I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to have your case reset to hire your own attorney? Before you signed and initialed this document, did you read this document? Did you understand what you read? And is everything in this document true and correct to the best of your knowledge? Okay, Mr. Jasper, you can have a seat in that first chair on the wall. The court coordinator is going to reset your case. Once your case is reset, you're free to go. And you have a blessed day. Thank you. Next case is cause number M333236. Case is style of state of Texas versus Kashira Detrice Spearman. Spearman, would you please come forward? Ms. Spearman, your full name is Kashira Detrice Spearman? Ms. Spearman, would you please raise your right hand? Ms. Spearman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Spearman, you may put your hand down. How are you doing, Ms. Spearman? You doing fine? That's good. Ms. Spearman, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Ms. Spearman, do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled Defendant?
Yes.
Ms. Spearman, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge? Ms. Spearman, read your answers. Someone from the district attorney's office is going to come out and talk to you. You can go back and have a seat where you were sitting.
Yes.
Next case is cause number 24CCCR 0392. Case is style of state of Texas versus Edwin Nelson. Mr. Nelson, is your full name Edwin Lydell Nelson? Mr. Nelson, would you please raise your right hand? Mr. Nelson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Mr. Nelson, you may put your hand down. How are you doing, Mr. Nelson? That's good. Mr. Nelson, I have before me. Uh-oh. He didn't sign the waiver. He needs, when he made the change, you need to sign the waiver. Should be one here. Make sure you read it. Okay, Mr. Nelson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Nelson, do you recognize this document?
No, sir.
Is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that state you would like to waive your right to an attorney to represent yourself?
Yes, sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document? Is this your signature on the line that's titled Defendant? Mr. Nelson, before you signed and initialed these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge? Mr. Nelson, I read your answers. You can go back and have a seat, and someone from the district attorney's office is going to come out and talk to you. Next case is cause number 23CCCR 1570, case of style of state of Texas versus Dylan Eduardo Garcia Rodriguez. Mr. Garcia Rodriguez, should you please come forward? Mr. Garcia Rodriguez, your full name is Dylan Eduardo Garcia Rodriguez? Mr. Garcia Rodriguez, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, ma'am.
You may put your hand down. How are you doing, Mr. Garcia Rodriguez? You doing good?
Yes, sir.
That's good. Now, Mr. Garcia Rodriguez, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendant? And are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there is a signature above the line that is titled Defendant. Is this your signature?
Yes.
Mr. Garcia Rodriguez, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Garcia Rodriguez, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you is Ms. Jennifer DeLodge. Ms. DeLodge is, actually, she's present in court. The court coordinator is going to give you information with Ms. DeLodge information on it. Ms. DeLodge will also be given information regarding you. Now, once she gives you that information, you may, if you want to hang around and talk to Ms. DeLodge, you can. Okay? So just have a seat in that first chair on the wall. Once you get that information, you'll be free to go and you have a blessed day. Well, actually, you sit at the chair, you can sit at the table. Just sit at the table with him. Yeah. Okay. Next case is called number 23CCCR 1242. Case is style of the state of Texas versus Joshua Lee White. Mr. White, your full name is Joshua Lee White. Mr. White, would you please raise your right hand? Mr. White, do you swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. White, you may put your hand down. How are you doing, Mr. White? I'm doing fine. Thanks for asking. Mr. White, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. White, do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
Or are these your initials on the line that state you'd like to request a court-appointed attorney? I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature? Mr. White, before you signed and initialed these documents that I just showed you, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. White, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that will be appointed to represent you is Attorney Brian Matuska. Attorney Matuska will be given information to contact you, and you will be given information to contact him. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Please have a seat in that first chair on the wall. Okay. Next case is cause number 24CCCR 0436. Case is style of state of Texas versus Jacoby Tobago Holland Jr. Mr. Holland, your full name is Jacoby Tobago Holland Jr. Mr. Holland, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Okay, you may put your hand down. How are you doing, Mr. Holland? I'm doing fine. Thanks for asking. Mr. Holland, I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
Or are these your initials on the line that state you would like to apply for court-appointed attorney?
Yes.
I also have another document. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Holland, before you signed and initialed these documents that I just showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge? Mr. Holland, I read your answers. Based on your answers, we meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that would be appointed to represent you in this case is Attorney Laura Peraza. Attorney Peraza will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information, but before she gives you that information, the bailiff is going to give you some bond conditions. And I'm going to go over these bond conditions with you. Mr. Holland, the bailiff has just handed you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes.
Any reasons follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3, The defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go to any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes, sir.
Now, condition number 4 does not apply. That only applies in the DWI case. Your case is not a DWI case. However, condition number 5 does apply. And that's on the next page. Condition number 5 states as follows. Defendant is prohibited from possessing a firearm or ammunition unless defendant is a peace officer as defined by Section 1.07 of Texas Penal Code, actively engaged in employment as a full sworn paid employee of a state agency or political subdivision. Do you understand that condition?
Yes, sir.
Now, Mr. Holland, if you violate any one of these conditions, your bond may be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? Okay, Mr. Holland, you can have a seat in that first chair and wait for your name to be called by the court coordinator. And once you finish at her window, you're free to go and you have a blessed day. Next case is cause number 24CCCR 0382. Case is style of state of Texas versus Kyle Minton Clifton. Mr. Clifton, your full name is Kyle Minton Clifton?
Yes, sir.
Mr. Clifton, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you
Yes,
God? You may put your hand down. How are you doing, Mr. Clifton?
Okay.
I'm doing fine. Thanks for asking, Mr. Clifton. I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that state you'd like to apply for court-appointed attorney?
Yes.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes, sir.
On page 2 of this same document, there is a signature above the line that is titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Clifton, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Clifton, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will be given information to contact her. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go and you have a blessed day. Please have a seat in that third chair on the wall. You're welcome. Next case is cause number 24CCCR 0410. Case is style of state of Texas versus Lawrence Edward Castile III. Mr. Castile, your full name is Lawrence Edward Castile III.
Yes.
Mr. Castile, would you please raise your right hand? Mr. Castile, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Castile, you may put your hand down. How are you doing, Mr. Castile?
Good.
I'm doing fine, thanks for asking. Mr. Castile, I have before me 2 documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes.
Is this your signature on the line that's titled Defendants? And are these your initials on the line that state you would like to apply for court-appointed attorneys? I have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Is this your signature?
Yes, sir.
Mr. Castile, before you sign and initial these documents, Did you read the documents?
Yes.
Did you understand what you read?
Yes.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Mr. Castile, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you, in this case, Attorney Nathan Reynolds. Attorney Reynolds will be given information to contact you. You will also be given information to contact him. Our court coordinator will give you the information. But before she gives you the information, the bailiff is going to hand you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that title?
Yes.
I'm going to go over this document with you, and it reads as follows. Following the return of a criminal information in County Court at Law Number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein are ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who, A, refuses to submit to test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. Do you understand that condition?
Yes, sir.
And condition number 3 and 4 does not apply. However, condition number 5 on page 2 does apply. And condition number 5 states as follows: the defendant is prohibited from possessing a firearm or ammunition unless the defendant is a peace officer as defined by section 1.07 of the Texas Penal Code, actively engaged in employment as a sworn, full-time paid employee of a state agency or political subdivision. Do you understand that condition?
Yes.
Now, Mr. Castile, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand that? And Mr. Castile, our court coordinator is going to give you your paperwork. Once you get the paperwork from the court coordinator, you'll be free to go. And you have a blessed day. Please have a seat in that third chair on the wall. Next two cases are cause number 24CCCR 0454 and cause number 24CCCR 0482. Both cases are styled the state of Texas versus Beatrice Louise Pollard. Ms. Pollard, your full name is Beatrice Louise Pollard?
Correct.
Ms. Pollard, would you please raise your right hand? Ms. Pollard, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Ms. Pollard, you may put your hand down. Now, just for the record, Ms. Pollard, I met you this morning, is that correct?
Yes.
In fact, I was introduced to you by a gentleman by the name of Ed Johnson. Okay. And at that time that he introduced me to you, you did not inform me that you had a case in this court. Is that correct?
Correct.
Okay. Other than that, we've never met, never talked about your case.
Correct.
Court never made no promises. That door is locked, sir? Never made any promise to you or anything
Correct.
about your case, okay?
Yes.
Now, state, if you think that there's a conflict of interest, the court be willing to recuse itself, or if there's an appearance of impropriety, the court would be willing to recuse itself. You have any objections to me serving or sitting as judge in this case?
No. State has no objections.
You have no objections? Okay. You waive any possible conflict of interest or any appearance of impropriety?
Yes, sir.
Okay. Now, Ms. Pollard, I have before me two documents. first document that I have is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature online as titled defendant?
Yes, sir.
And are these your initials on a line that state
Yes, sir.
you'd like to apply for a court-appointed attorney? I also have another document here that is titled Jefferson County Affidavit of Indigence. Do you recognize this document?
Yes.
Is this your signature on page 2 of this document?
Yes.
Now, Ms. Pollard, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay, now, Ms. Pollard, I read your answers. I have some questions about some answers on the affidavit of indigence. Okay. And what I'll do, I'll just put this on mute.
Yeah.
And so we're gonna redo the numbers. So actually, it's gonna go, Mr. Pollard. Court has made the adjustments on his form. And, so all the other, figures are correct?
Yes.
Okay. Based on the based on the figures, you do not qualify for an appointment of a court-appointed attorney.
Yes.
Okay, so now at this point, you have one or two options. You can ask that your case be reset to give you an opportunity to go out and hire an attorney. You can talk to some attorneys, see if you can afford to hire an attorney. Or the other option, according to the form, is you can waive your right to an attorney and represent yourself. Okay,
I get it.
okay, good. She's gonna get this form to you so that you can make that adjustment. She's just gonna strike through the one that says that she wants to request a court-appointed attorney. She could put one line through it, and then now, Ms. Pollard, you want your case reset to hire your own attorney, is that correct?
Yeah.
Okay, your case is gonna be reset to give you an opportunity to hire your own attorney. Our court coordinator is gonna give you a reset once you get your, once you get your reset, you'll be free to go, but before she does that, I need to give you some bond conditions. Ms. Bailiff, could you hand these bond conditions to her? Okay. Now, Ms. Pollard, the bailiff has just handed you a document that is titled Standard Bond Conditions in County Court at Law number 2. Do you see that title?
Yes, sir.
I'm gonna go over this document with you. This document states that following the return of a criminal information in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes, sir.
And condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. The court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol. The test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition?
Yes.
And condition number 3 does not apply. Condition number 4 does apply because your case is a subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code. Do you understand that?
Yes, sir.
And section condition number 4 reads as follows. A defendant whose information charges any subsequent offense listed under section 49.04 through 4906 of the Texas Penal Code shall not operate any motor vehicle unless the vehicle is equipped with an interlock device mechanism that makes impractical the operation of the vehicle if ethyl alcohol is detected in the breath of the operator, and said device shall be installed at the defendant's expense with written verifications of such installation being submitted to the court on or before 3 days after the date. Do you understand that condition?
Yes, sir.
Now, earlier you mentioned that you already have the interlock.
We saw December 31st. I got the paperwork.
Okay, we're gonna need a copy of that paperwork for your file. Now, do you understand that condition?
Yes.
Condition number 5, the defendant shall obtain, maintain, and pay for and have no violations with the ignition interlock device, mobile device. Any violation will be grounds for revocation. Do you understand that?
Yes, sir.
That means your bond will be revoked.
Yes.
Condition number 6, the defendant must attend AA meetings 3 times a week and provide proof to the court. Do you understand that condition?
Yes.
And I'm going to give you some paperwork about Ms. Bailiff, could you hand this to? And the bailiff is handing you 2 documents. The first document give you locations of meetings for NANA in our Southeast Texas, in Southeast Texas. And the other document is the document that you will bring with you to the meetings so that a sponsor will sign verifying that you did attend. Every time that you come to court, you need to bring that form back with you so that we can verify that you have been attending AANA meetings 3 times a week. Do you understand?
Yes, sir.
Okay. Now, Ms. Pollard, if you violate any one of these bond conditions, your bond can be revoked. And if your bond is revoked, a warrant will be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Do you understand?
Yes.
Now, I think you said you had the, do you have the interlock form with you here?
Yes, sir.
Okay, we'll give you opportunity. You're gonna have a seat in the first chair, but you can go get the form and give it to the court coordinator so that she can make a copy.
Okay.
Next case is cause number 24 CCCR 0212, case is style of State of Texas versus Bryant Wayne Robinson Jr. Mr. Robinson, your full name is Bryant Wayne Robinson Jr.? Mr. Robinson, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? You may put your hand down. How are you doing, Mr. Robinson? You doing good? That's good. Mr. Robinson, I have before me a document. I have 2 documents. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document? Is this your signature on the line that's titled defendant? Or are these your initials on a line that states you'd like to apply for court-appointed attorney?
Yes, sir.
I also have another document that is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this document, there's a signature above the line that's titled defendant's signature. Is this your signature? Mr. Robinson, before you sign the initial of these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Robinson, I read your answers. I need to ask you some questions about some of the answers that you have here on this affidavit of indigence. I'll just put this on mute. Jefferson County Court at Law number 2 is back in session. The court is in session. In cause number 23 CCCR 2476, case is styled the State of Texas versus Tichelle Trulette McKinney. Ms. McKinney, is that your full name? Ms. McKinney, would you please raise your right hand? Ms. McKinney, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Ms. McKinney, you may put your hand down. How are you doing, Ms. McKinney? You doing okay? You are. Ms. McKinney, you're represented in your case by your attorney, Attorney Jennifer Delage. Ms. Delage, how are you doing?
Fantastic. How are you, Judge?
I'm doing fine. Mr. Lodge, do you waive a record in Ms. McKinney's case?
Yes, Your Honor.
State is represented in this case by Attorney Haley Simmons. Attorney Simmons, how are you doing?
I'm great, Judge, thank you.
Ms. McKinney, I have before me a document that is titled Information Sheet. This information sheet alleges that on or about October 11th of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of criminal mischief. Ms. McKinney, do you understand what you have been charged with?
Yes.
And to this Class B misdemeanor of criminal mischief, how do you plead guilty, not guilty, or no contest?
No.
Are you pleading no contest freely and voluntarily? And are you pleading no contest because you do not wish to fight or contest the charges?
Yes.
Ms. McKinney, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes.
On page 2 of this same document, there are a set of initials on a line next to a box that's checked nola contendere, which means no contest. Did you place your initials on this document? On page 3 of the same document, there is a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes.
And is this your signature above the line that's titled defendant?
Yes.
At the top of this document, there's one box that's checked. The box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? I also have another document on paper that is titled Discovery Certification. Do you recognize this document? And is this your signature on the line that's titled defendant? Ms. McKinney, before you signed and initialed all of these documents that I just showed you, did your attorney go over these documents with you? And did you read and understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge? Ms. McKinney, are you a citizen of the United States? State,
All for states one.
any objections? No objections. States exhibit number 1 will be admitted. Mr. Lodge, you've advised and counseled Ms. McKinney, is there any evidence that she is currently mentally incompetent to stand trial?
No, Your Honor.
Ms. McKinney, your attorney, Ms. Lodge, has advised and counseled you. Are you satisfied with her representation?
I am.
Has she provided full, effective, and competent legal representation?
Yes.
Ms. McKinney, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
Yes, Your Honor.
And what is that agreement?
In exchange for defendant's plea of no contest, the state's offering 1 year deferred with the fine to be waived, 40 hours community service, and $546.04 in restitution to be paid to Raquel Simmons.
Mr. Lodge, are you appointed in this case?
Yes, Your Honor.
What is the court cost?
277.
Okay. Ms. McKinney, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay restitution of $546.04 to the complaining witness Raquel Simmons. You'll also be required to reimburse Jefferson County court-appointed attorney's fees of $250. You'll be required to pay, you will not be required to pay a fine. However, you will be required to pay court costs of $277. You'll be required to pay Jefferson County probation fee of $60 a month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you'll be required to pay each month, is $181 a month. Will you be able to pay the $181 a month?
That's assuming, Judge, just to clarify, so she does not have to pay the restitution in full today?
That's what I was under the assumption of. She was actually going to pay the restitution in full today.
Oh,
That's if it was that, yeah, but that under deferred no or probation, I thought you.
But if she can spread it out, I think she.
She can spread.
She can still pay it up front, correct?
yeah. Yeah, you still can pay. Well, let me do this here. Because if the way they do it, if she pays it up front, they might apply that to probation fees and all that other stuff.
It may be better to do it spread out.
Whatever you give them today, that's gonna go toward all of this.
Yeah.
Unless you have a lump sum, I don't know how to, you would have to talk to the probation department about that. Okay, the state is offering that you serve 1 year deferred adjudicated probation. During the 1 year probationary period, you'll be required to pay restitution in the amount of $546.04 to Raquel Simmons, the complaining witness in the case. You'll be required to reimburse Jefferson County court-appointed attorney's fees of $250. You'll be required to pay court costs of $277. You will not be required to pay a fine. You will be required to pay a probation fee of $60 each month, a urinalysis fee of $15 each month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $181 a month.
No.
It's spread out within those.
So
12
it's spread out.
probation.
Okay, now are you able to pay the 100 and, no, you don't have to pay it. I mean, the question is, can you pay it? If you can, you can. If you can't, you can't, and then we'll proceed depending on how you answer the question. You say you're not sure. Okay, well, I need to know either yes or no. Can you pay it or can you not pay it? You can't pay it, okay. So let's look at her affidavit of indigence. You got her affidavit. Let's see. Okay. Miss McKinney, I have a document before me that's titled Jefferson County Affidavit of Indigence. I'm handing this document to your attorney. Mr. Lodge, could you show that document to you?
Yes, Judge, can we have like 1 minute?
Just a brief recess. Ms.
I need
Porter
to walk
stepped
outside.
outside to talk to Andrew real quick upstairs. It's his case. I'm just
Oh.
reviewing the offer for him.
Okay,
They wanna
okay, we'll be in
confirm
recess.
real quick.
She should have been a doctor.
I was gonna be like.
Okay, I see the handwriting. Okay, okay, Miss, let's see, the day is the 23rd. The state is dismissing your case. And I'm signing the dismissal. Okay, there we go. I just signed the dismissal. Ms. Spearman, the court coordinator is going to get a copy of the dismissal. Once you get a copy of the dismissal from the court coordinator, you'll be free to go. And you have a blessed day.
Yes, sir.
You're welcome. Edwin Liddell
You want a copy?
Nelson, yes, Miss, yes, she's gonna get a copy of her dismissal. This is cause number 24 CCCR 0392. And Mr. Nelson, the state is dismissing this case because you completed the options class
Yeah.
and signed an affidavit of non-process from the victim, is that correct?
Correct. I spoke with the victim. She's verbally said today she's not gonna assist in the prosecution at all, even if you take the trial.
Case is being dismissed. I'm signing the dismissal.
With me.
Okay. Mr. Nelson, I just signed the dismissal. You're gonna be able to get a copy of the dismissal from our court coordinator. Once you get a copy of the dismissal, you're free to go and you have a blessed day.
Now, with this young lady, as long as she brings the receipt, I'll dismiss it by 4, but if she does not bring the receipt, is she gonna be placed back on docket for a couple of days from now, or?
She gonna bring her receipt.
I'm just saying, I just wanna make sure.
Oh, no, she needs to bring the receipt. If she don't bring the receipt, you need to appear here in court by 4 o'clock. If you appear in court, your bond can be forfeited and a warrant issued for your arrest. Okay, so you're gonna have to 4 o'clock to pay it. So she's gonna,
Oh, I don't know where they.
he's sitting right there.
Here's his plate.
Edwin Nelson, what's that?
Ready for him? She'll be back.
So all of these, hold on. These are just the paperwork we had. We had Nelson. All of this paper, this is gonna be shredded.
Okay.
Plus the state dismissed it.
And the victim.
Let me, Jefferson County Court of Law number 2 is back in session. The court is in session in cause number 24 CCCR 0212. Case is style of State of Texas versus Bryant Wayne Robinson Jr. Mr. Robinson, is that your full name? Is that your full name?
Yes, sir.
Mr. Robinson, would you please raise your right hand? Mr. Robinson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Mr. Robinson, you may put your hand down. Mr. Robinson, I have before me, now earlier you appeared, I have before me a document that is titled Judge's Explanation of Rights of Defendants Without Attorney. You recognize this document? And is this your signature online inside of defendant?
Yes, sir.
Are these your initials online that state you'd like to apply for a court-appointed attorney? I also have another document before me. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that is titled Defendant Signature. Is this your signature? Now, Mr. Robinson, before you signed and initialed these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Mr. Robinson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney that will be appointed to represent you as Attorney Lindsey Scott. Attorney Scott will be given information to contact you. You will also be given information to contact her. Our court coordinator will give you that information. Once you get the information from the court coordinator, you'll be free to go. When you have a blessed day, please have a seat in the first chair on the wall. Next case is, the court's going to what I did with Clifton. Clifton must have been 3 points higher. Okay, we're still in session. In the arraignment docket. Next case is cause number 24 CCCR 0368. Case is styled the State of Texas versus Kirtrick Keith Paul. Kirtrick Keith Paul was scheduled for arraignment on today's date at 9 a.m. in County Court at Law number 2. At about 9 a.m., the court's bailiff called the name of Kirtrick Paul at the courthouse door. Kirtrick Paul did not answer. Kirtrick Paul has not appeared in court since the court has been in session. The time now is 12:49 p.m. on today's date of April 23rd of 2024. Ms. Bailiff, would you please call the name of Kirtrick Paul at the courthouse door?
Kirtrick Paul. Kirtrick Paul. No, it's my friend.
Kirtrick Paul, name was just called again at the courthouse door. Kirtrick Paul did not answer. A reasonable time has passed to give Mr. Paul an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Same with the bond forfeiture.
That motion will be granted. Kirtrick Paul bond will be forfeited and warrant shall be issued for his arrest. And cause number 24 CCCR 0368. Next case is cause number 23 CCCR 0342. Case is styled the State of Texas versus Shervin Rashad Provost. Shervin Provost was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Shervin Provost at the courthouse door. Shervin Provost did not answer. Shervin Provost has not appeared in court since the court's been in session. The time now is 12:50 p.m. on today's date of April 23rd of 2024. Ms. Bailiff, would you please call the name of Shervin Provost at the courthouse door?
Shervin Provost. There's my God.
Sherman Provost's name was just called again at the courthouse door. Sherman Provost did not answer. A reasonable time has passed to give Mr. Provost an opportunity to appear in court. He has not appeared in court. State, do you have a motion? That motion will be granted. Sherman Provost bond will be forfeited, which a warrant shall be issued for his arrest in cause number 23CCCR 0342. And this will conclude the calling of the court's arraignment docket in County Court at Law number 2, Jefferson County, Texas, on today's date, April 23rd, 2023. The court will be in recess until 1:30 when we pick the jury for our trial.